Wait here.
Mhm. Mhm.
So good morning, good afternoon, good evening. I'm Chip Brower, Chair of the Institute for Transnational Arbitration. Welcome to the latest iteration of CAIL's program, its series on promoting the rule of law. I don't have to tell you, we live in disturbed and chaotic times. Many of us feel disoriented by rapidly shifting norms. And in these kinds of situations, we often turn to leaders to help us make sense of things. Today, I am joined by two great leaders, Lucy Reed and Jose Alvarez. Both are past presidents of the American Society of International Law. Both have spent significant time in private practice, in government service, and legal education. Jose is the recipient of the highest honor bestowed by the American Society of International Law, the Hudson Medal. He is one of the world's leading scholars on international organizations and also a co-author of a recent book on the Convention for the Elimination of All Forms of Discrimination Against Women. Lucy is past chair of the ITA, the first female chair of the ITA. And among other things, many other things, she is an expert on international humanitarian claims, having served on the Eritrea-Ethiopia Claims Commission, as well as the Board of Register of Damage caused by the aggression of the Russian Federation against Ukraine. Now, before turning the spotlight on Lucy and Jose, I want to offer a few framing comments. Our topic is America First in International Law. And I have struggled to come up with a visual depiction of the relationship between these two concepts. Obviously, they do not nest well together. There is a sense of contradiction. But I've come to visualize the two as a T, a capital T on its side, or maybe a traffic sign signaling a T intersection to the right. So imagine a horizontal bar going from my left to my right, and on the far right-hand side connecting to a vertical bar. Starting at the left end of that horizontal bar, imagine a power-based system of human and international relations where every contention is resolved through the application of force, leverage, or power. This is the Hobbesian state of nature, the war of all against all, the place where the strong always win and the weak always lose. It is a place where life is nasty, brutish, and short. But moving from that left end to the right end, we see the development of a law-based system where contentions increasingly are resolved through the objective application of legal rules. It is a place where the strong and the weak have a more equal chance of winning or losing based on the merits of their positions as opposed to their relative endowments with power. But the journey does not stop upon the arrival at a law-based system. The question then becomes the vertical orientation a people selects. There are two choices. First, they can ascend to the heavens. They can ascend to the heavens to a rule of law system in which every contention is resolved through the application of just and universal rules. It is a system in which everyone, even the leader, is subject to ordinary law and the jurisdiction of ordinary courts. But what if they do not ascend to the heavens? As Grant Gilmore observed in the Ages of American Law, there is another direction. In hell, there will be nothing but law, he said. In hell, there will be nothing but law. His point was that law reflects but does not determine the moral worth of a society. In a reasonably just society, there will be reasonably just laws. In an unjust society, there will be unjust laws. And in hell, you can imagine a cruel and powerful leader using law as one of the transmission belts for inflicting endless and unimaginable suffering. It is also a place where the leader is not subject to ordinary law or the jurisdiction of ordinary courts. So for the past 80 years, the American legal system and the post-war World War II international legal system have trended towards the heavens, but now we are experiencing a rapid and frightening descent. At the international level, the trajectory feels like it is trending downwards and towards the left. In other words, towards an increasingly power-oriented system characterized by elements of the war of all against all. In this context, America First feels transactional, imperialistic, driven solely by interest. At times, it feels like an America without friends, an America without values, an America above the law, an America that blows up the global trading system, that abandons global leadership, that mocks her traditional allies and questions their right to exist. Imagine how our allies feel. As the proud parent of a trans child, I understand how deeply it cuts when the most powerful man in the world, mocks and questions the right to exist of something or someone you love. And then shifting to the domestic plane, the trajectory sometimes feels like a plunging towards that place where there will be nothing but law, a place where leaders are not bound by ordinary law or the jurisdiction of ordinary courts. One can feel this in a recent exchange when the president asked the governor of Maine if she intended to implement his executive order on transgender athletes. And when the governor replied that her administration was following federal and state law, the president replied, we are the law. We are the law. One can feel the trajectory in the normalization of corruption and racism, the rendition of protected migrants to a rented gulag without trial, the systematic disrespect for judicial process, and the extortionate abuse of power against lawyers merely for seeking the application of ordinary law in ordinary courts. But perhaps the most striking aspect has been the realization that the ascent into the heavens was fluid, reversible, far weaker, less rooted than we ever imagined. While talking to us, Grant Gilmore described this as the beginning of wisdom, the point at which we realize that the law is neither fixed nor permanent. To the contrary, it is an unstable mass in a precarious equilibrium. Progress is not inevitable. We are stewards charged with and responsible for achieving progress and also complicit in any failure. And we should expect to see the stitching and unstitching of social fabric as we allow consensus to pass into and out of existence. So turning to Lucy and Jose, and also the audience, you can submit questions in the chat. We will try to get to them if time permits. And if we do have time, the president of the Center for American and International Law, T.L. Cubbage, will appear to present your questions. But let me get it started. First Lucy, then Jose. Without attempting any sort of comprehensive definition, what stands out as the main features of the emerging America First policy?
Thank you, Chip, for having us and for your introduction. And on behalf of Jose and myself, thank you all for listening. We are in somewhat uncharted waters. I'm happy to do some swimming here, but we may need to look at our notes more than usual to be able to answer the questions most thoroughly. I propose to start with a brief description of America First in order to pinpoint how we're discussing it here today. It is a telling and not a fortuitous slogan. Obviously, the basic principle of the Trump administration's version of America First is to put domestic policy first over foreign or global affairs. The descriptors that we keep reading, of course, are nationalism, unilateralism, isolationism, protectionist trade policy. But the phrase is not new. It was reportedly first popularized by Woodrow Wilson in his 1916 campaign to keep the United States out of World War I. And then the formal committee called the America First Committee was a major isolationist group advocating to keep the United States out of World War II with very obvious or transparent anti-Semitic and fascist element. You'll remember Charles Lindbergh was involved in that. And the America First Committee was a favorite with the Ku Klux Klan in the 1920s. Now, Trump first used the phrase America First in the context of his first campaign. And then when he was first elected president, as his formal capital F, capital P, foreign policy, the emphasis being on disentangling the United States from treaties and international organizations. And now we're living with the 2022 America First agenda of the America First Policy Institute, which has 10 pillars, not to be confused with, but parallel to the Heritage Foundation's Project 2025 with its 4 pillars. So how does it work? We know how it works. On day one, Trump issued executive orders to withdraw from the Paris Climate Accord, from the World Health Organization, and ordered a 90-day pause on delivery of all United States foreign aid. And you all know more examples, so I won't give any more examples. What might come next, perhaps looking at Project 2025, would be a U.S. exit from the IMF and the World Bank. So, Chip, with apologies, back to your exact question. As used in the second Trump administration, what are the general features of America First in relation to foreign policy and international law? One answer to that is it's not really America First, it's America Best, America Alone, or America Rogue. To me, preparing for this webinar made me think a lot about this. There's a confusing mix of extreme unilateralism in America First, suggesting, as I say, America Alone. But at the same time, there's Trump's love of bilateral deal making from the platform of America First. There's a total rejection of the role and the burdens of being the post-World War II stabilizing force in international relations, while also wanting to call all the shots in world order. There's certainly a total disregard for diplomats, for diplomacy, as evidenced by the shocking treatment of President Zelensky in the Oval Office, which was just reprised in the ambush of President Ramaphosa, which, I don't know, maybe it's going too far, but I did have a sense of the dignified Oval Office looking more like the Apprentice show. Not that I ever watched it. But more relevant here for this webinar, Jose, and Jose doesn't completely agree with me on this, but I see that there's a wholesale rejection of any rule of domestic or international law. Jose is going to offer some specifics, as do the policy experts and the professors and the journalists we read every day. But my big concern is that America First, as it's unfolding daily, doesn't even consider international law, even to ignore it or give it a description and then reject it. You know, as international lawyers, we're all used to the questions: does international law matter? Is international law law? Is international law international? But here in America First, it is an irrelevancy. And government lawyers are irrelevant. International lawyers and professors are irrelevant. And that is something, that's the uncharted water that I see we international lawyers in. So Jose, you have some more specifics.
Yeah. Jose, if I could just add on to that a little bit. Lucy was defining America First in part by what it disregards. Do you have anything to add to the list that America First in particular disregards?
So one of the things it disregards is the fact that if you really were thinking of America coming first, that would be something that international lawyers would really not have many complaints about. That is, international law is international. It's created by states for their interests. And when you look at the level of compliance, when they comply with international law, it's because they think they're getting a particular reciprocal benefit. We treat your diplomats this way, you will treat them the same. We treat your citizens decently, they will treat ours. We treat your prisoners of war decently, and they will treat ours. That specific reciprocity seems lost when you ignore the rule of law altogether. But deal making is interesting because that raises the other reason international law is valuable. Political scientists call it diffuse reciprocity. When you conclude a deal, you're relying on the diffuse reputation you have for abiding by pacts, pacta sunt servanda. You feel that if you make a promise, that it will stick and others will trust you on that. And that's not reciprocal necessarily in a tit-for-tat basis, but it is based on your reputation for complying with it. When Jimmy Carter put human rights at the forefront of his agenda, when Bush Sr. turned to the UN to get Iraq out of Kuwait, both of them thought of international law as tools of statecraft. Both of them thought this was consistent with making America first. America firsters seem to depart from the idea that is inherent in the post-World War II legal order, that it basically is about benefiting all states. They seem to think that law, and here I would say to a great extent even domestic law, is for the weak, and that international law elevates the interests of others, but not the United States. So let me add two things to the characteristics that I pretty much agree with that Lucy just talked about. It seems to ignore the late Joseph Nye's really strong contribution in political science that states enjoy, especially the United States, international soft power. And that is premised on the fact that it is perceived or thinks of itself and tries to model, albeit very selectively, itself on how to adhere to certain principles. And that basically this is for other democracies especially to follow. It shreds that normative value and the US's global instrument when we seem to be appealing to non-principles at all. And that, of course, shreds the reason many immigrants, including myself, came to this country seeking something different from authoritarian repression. Now, examples of that soft power that is being ignored include the fact that the United States is one of the few powerful governments that has subjected itself to all the major anti-corruption review mechanisms on the planet, that it has been a strong defender of peaceful dispute settlement, in particular for trade and investment disputes that have in the past often led to breaches of the peace, that it has in the past, albeit imperfectively, advanced fundamental human rights, including promoting women's equality and economic empowerment. By not talking about or even considering as one of the factors the reasons that we have become so powerful, we cede the moral high ground to others. And that means that we're in the unlikely place where China, for instance, the country that has had to be persuaded to join the WTO, now becomes a plausible defender of solving trade problems through arbitration instead of economic coercion. That China, the country that has strongly touted the coal industry, has now making a somewhat credible case that it still is a leader and cares about climate change, mitigation, and adaptation. And that China, a country that has repressed so much, including with respect to education and who gets it in their own country, is now suggesting that it is the strongest supporter of UNESCO, and that China, which let's just say has had some issues with adhering to the international health regulations under the World Health Organization during COVID, that China is not the one that's walking out of the World Health Organization. So that's one aspect that I think needs to be highlighted, the international soft law of the United States and giving that up. The second is, and this is far more obvious, is that we're basically adhering to law, but it's basically Carl Schmitt's law of the exception. That is, we're highlighting all the places that law makes an exception that permits the president to do whatever the president wants to do. We see this in suggesting there's an immigrant invasion or there's a fentanyl crisis at the border. And so we see that playing out. with respect to whether habeas applies, the Alien Enemies Act, or whether the International Emergency Powers Act on emergencies permits us to do tariffs. But all of those things, the law of the exception, have international components. There is an emergency clause under the International Covenant on Civil and Political Rights, but it permits derogations from only some of those rights, not, for example, torture, and says you're supposed to justify your emergency exceptions and that it is temporary. You notice nobody is asserting that exception precisely because it is not totally self-judging. There is an exception under Article 21 under the WTO. Nobody's asserting it because the WTO case law has suggested that is not self-judging. There are essential security exceptions to bilateral investment treaties. Again, this is not the kind of exception in the law that is scrutinized or even subject to legal analysis. You don't notice the administration citing to law with respect to the essential security exception or any of these other things. But one quick point is a caveat. Let's not over-intellectualize America First. And Lucy has suggested it might be called Jacksonian realism, nationalist, sovereigntist, or isolationist. Actually, it's closer to the title of an Oscar-winning film, Everything, Everywhere, All at Once, right? So what we have is transactional deal-making, the art of the deal, which makes it possible for Trump on May 13th in Saudi Arabia saying something that the third world scholars, Twailers, would probably support. That is, we have no business intruding on your domestic jurisdiction on human rights and everything else. But that, which is obviously a policy you could try to justify on intellectual grounds, is followed a few days later, as Lucy talks about, with the South Africa's president charging that government with, totally implausibly, white genocide. Now, you can accuse the South African government of many wrongs, but genocide just isn't one of them. And it seems to turn, as the South African president sort of jokingly suggested, on the fact that his country does not have a plane to offer the president. So it is purely transactional, unprincipled in many ways. And we need to do a better job as lawyers, other than hand-wringing, which I suspect most of this hour will be about. That is, we need to better explain why protecting settled expectations, which lawyers value, is also something that makes America great. The credibility of our deals, and pausing the enforcement, for example, of the Foreign Corrupt Practices Act, turning the Constitution's emoluments clause into sort of a joke for late-night comedians. All of those things have parallels in treaty obligations. We are parties to the OECD, UN, and inter-American conventions that make bribes to governments illegal, and also say, at least one of them, no conflicts of interest should be permitted for those who hold government office. And what we need to tell the story better is that most US businesses actually support those rules, and that the Trump administration is somewhat outdated to think that it's back in the 1990s when there was some initial resistance to that by US businesses. These days, most businesses, including our own, say we need these anti-corruption rules to avoid shakedowns by government. It's a defense from those actions. It enhances the competitiveness of US companies in international markets, and it recognizes ultimately the truth that the wealth of nations is harmed by corruption. So I think it's not enough to bash America First policies. It's not enough to suggest we need to comply with international law. We need to prove to the naysayers that international law has always been a force for making America great. And that means we need, as good lawyers always do, to listen closely to at least the fair critiques of international law and its institutions that come from MAGA and America Firsters. And we need to reform international law and those institutions to better advance the needs of all states, including our own.
Thank you, Jose and Lucy. As I was listening, I heard a number of concepts that go beyond international law specifically. soft power, respect for legality, reputation, and credibility. Now, the title of this webinar is America First in International Law, but my framing comments focused on the rule of law. Your discussion has gone far beyond international law. So let me ask you, is there a distinction between international law and the international rule of law? Is it important? And how is America First in friction with one or both? Maybe Lucy, you can start.
Thank you, Chip. For purposes of what we're talking about today, I don't think there's an important distinction between the rule of law and international law. And America First, in its worst aspects, does threaten both. As Jose says, our challenge is to stick to our values. And, it's not just businesses and lawyers that value certainty and predictability. It's also citizens and taxpayers, from whom I think we will be hearing more in coming months. But rule of law. Do you want to say something?
No. Just crossing my fingers on whether the citizens will wake up to this.
Well, let's remember, the popular vote was pretty much 50-50. Not overnight, all Americans didn't turn into deporters, but we'll see. All right. Rule of law is a big concept. It's defined in many ways. It's abused in many ways, but I thought it would be good, as I did with America First, to go back to some of the basics. So let me give you two sources on the larger meaning of the rule of law. One comes from Lord Bingham's famous book called The Rule of Law. And what he says, and I quote, the core of the existing principle is that all persons and authorities within the state, whether public or private, should be bound by, and I emphasize, entitled to the benefit of laws publicly made, taking effect generally in the future, and publicly administered in the courts, end quote. Closer to home, I can cite from Thomas Paine's Common Sense in 1776, that's 250 years ago, and I quote Thomas Paine, "In America, the law is king. For as in absolute governments, the king is law, so in free countries, the law ought to be king, and there ought to be no other," end quote. And I won't talk about law and hell, Chip. But for my comments, as a practicing lawyer, mostly, I want to emphasize that the rule of law is heavily procedure based. We talk about the importance of transparency, predictability, non-arbitrariness, non-discrimination, and at the end of the day, that these procedural rights will be judicially protected by the courts having the last say. And I won't belabor this, but many accuse the Trump administration of acting imperially. Well, they say it, claiming to be above the law, whether that's meant to be serious or not. It doesn't matter, because the law doesn't seem to matter to them, whether they're above it or below it or around it. The key example to me is the mass deportations that are occurring under the Alien Enemies Act of 1798. This is the fourth time that act has ever been used, and the first time it's been used outside of an actual war. And I don't think it's debatable that thousands of immigrants crossing the border, even if they are gang members, do not constitute the type of invasion that's equivalent to war, as mentioned in that act. I note also that the Trump administration is considering suspending immigrants' habeas corpus rights in court before they're deported. That's, of course, when habeas matters, is before they're deported from U.S. territory. And I think it's worth always remembering the language of the Constitution, that habeas is a privilege that, and I quote, "shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it." Public safety, serious public safety. Now, habeas has been suspended also, coincidentally, only 4 times. the last in 1941 when Pearl Harbor was attacked. And when, sorry, I'm playing my alarmist role for good cop, bad cop, Jose, when we hear the secretary or the head of Homeland Security show she doesn't know what habeas means, that she thinks it's a deportation clause in the Constitution, there's some cause for worry. But having said that, deportation without any hearing or other procedure or process to assess an immigrant's legal or illegal status, especially when it leads to imprisonment on foreign territory, potential torture, potential death, actually, is per se a violation of the rule of law. You can have a million definitions, but that is a violation of the rule of law. It's an abuse of constitutional rights under the color of law, in my view, with the executive branch choosing to be judge and jury without the guardrails right now from Congress. And I've been, for different reasons, I've been reading recently back into the Pinochet regime and what was happening in 1973. And we're not anywhere close to that, but it does bring back those memories. And it prompted me to look up a decision that we made on the Eritrea-Ethiopia Claims Commission back in 2000 in what we called the civilians claims. It's publicly available. And what we did was find that Ethiopia was liable for violating international humanitarian law by mass expulsions of dual national Ethiopian Eritreans after arbitrarily taking away the Ethiopian nationality of those dual nationals without allowing individualized screening in a purported process before deportation. Now, fortunately, our judiciary has its finger in the dike, I think. I'm proud of what a lot of the courts are doing in the United States right now. One example, the Supreme Court did criticize the Trump administration for giving only 1 day's notice to Venezuelan immigrants in Texas before deportation. But I was thinking as we prepared for this that I should be proud that the measure is 1 day compared to what we did with the Eritreans and Ethiopians. So it's difficult. But anyway, I'll close by noting that just last week on the 19th of May, on an emergency application, the Supreme Court allowed the Trump administration to remove protections, most of the protections, from 350,000 Venezuelan immigrants who were in the US legally under the temporary protected status that was pending appeal in California. So we don't know the end of that story. But that program came from George H.W. Bush. For reasons, as Jose keeps talking about, the benefit of the United States and our businesses and our schools and our communities to have legal immigrants here.
Remember when the president was talking about a kinder, gentler America and how quaint that sounds today.
Hold on. Yes.
Jose, so
You
if we were talking about international law, right, and just international law by itself, and we wanted to know what it required, we would look at treaties, we would look at custom, things like that. Lucy was emphasizing that rule of law, it goes beyond that. It is largely procedural. So if we're thinking not just about international law as such, but the rule of international law, what are the other things that one would need to take into account?
So I think for purposes of argument, it is okay to try to distinguish the difference between what many people focus on, which is whether or not we are complying with the letter of our treaties, which for many people is the part of international law that they think is the most serious. But I think, as you're suggesting, and I think Lucy is also going there is a broader concept of adhering to the international rule of law. And so one way of understanding that is we've progressed far more than just having the black letter of the treaties. We have considerable treatification, where a bunch of treaties are addressing and developing the law over time, but we also have juridification. We have a lot of international courts. We have a lot of human rights bodies that are credibly authorized with authoritative interpretation of those treaties. We have internationalized interpreters of constitutions like the UN Charter and the constitutions of other international organizations. And a faithful adherence to the rule of law means not just looking at the plain language of the treaties, but what have those interpreters said about it, and what international soft law, if you want to call it that, has been produced. And at least adherence to the international rule of law is not just you should consider that, but you should explain deviations of why you don't want to follow an interpretation of a treaty. That at least shows respect for those interpretations over time. Now,
Exactly.
with respect to the first one, in compliance with the Black Letter of Treaties, well, one way of approaching this, and at some future point, I would urge those viewing to try to do this, is take the 100 days of the Trump administration. The New York Times has made that quite easy, and compare it to, say, the 100 ways international law shapes our lives that Lucy Reed and others, Lucinda, has also done in the American Society of International Law. I'm not saying they compare in terms of the same things each one focuses on, but I actually don't think that it would be so crazy to point to 100 ways international law violates not just the letter of the law, but the international rule of law in just those first 100 ways. Now, of course, the compliance part is easy. The rent-a-gulag arrangements with El Salvador, Sudan, Libya, and Rwanda violate numerous human rights treaties, including custom, even U.S. domestic statutes. So we're talking about, for example, Article 3 of the Convention Against Torture, and also the Domestic Law, Foreign Affairs Reform and Restructuring Act of 1998. And then tariffs, imposed and threatened. Once upon a time, in a galaxy long ago, we recognized that the WTO's rules require not just the avoidance of tariffs, but avoiding threatening tariffs, because that is a violation of the settled expectations of the WTO regime. And in that same galaxy, long ago, before a 301 panel of the WTO, we said we recognize that problem. And because we recognize that the threat of tariffs is bad, we want to assure this panel that the U.S. will not use existing legislation that permits the imposition of tariffs. We will not use it against a state that is a party to the WTO. In my international law book, case book that I use in class by Laurie Damrosch and others, it actually suggests that as an example of a legally binding unilateral act. How quaint. So that is yet another example. It is, of course, legally possible for the United States, within the terms of its acceptance of international treaties, to exit from them. But when it does so, it needs to adhere to the terms of its withdrawal. With respect to the World Health Organization, we cannot just ignore the conditions we ourselves imposed on exit. That is to have 1 year's notice, and during that period, we must comply with the obligations under the WHO, including paying any arrears. There are many more examples, though, including from executive orders to the president's statements on social media, that violate those qualities that Lucy was talking about from Lord Bingham. That is, the qualities of equal application, transparency, accessibility, legally bound discretion, and so forth. And I would be the first to argue that it's a never-ending struggle to get the international system to adhere to rule of law values. And it is therefore tempting to just focus on the black letter of treaties. But I think that the effort to try to adhere to the rule of law, to explain what we're doing, to put lawyers, including in the Office of Legal Counsel, to actually articulate the legal arguments. And keep in mind that when it comes to international law, they frequently don't have to, because U.S. courts don't focus on it because of restrictions on the fact that many treaties are not self-executing and other bars to hearing it in court. So it's up to us, the Academy, it's up to NGOs, it's up to international organizations, it's up to the international community as a whole to point up to point out when the US is not adhering to that broader concept of international rule of law. The most prominent example is climate change. So the executive order says we will terminate all attendant obligations when we exit from the Paris Agreement on climate. Well, what does that mean? Under the rule of law, we have to have 1 year notice under that agreement. We also have a duty to issue our own nationally determined contributions, or NDCs, that is due this year for the period 2030-35. We also have, at least under estoppel, duties to respect our own prior commitments to collective climate-related finance. And that comes under the framework agreement that we did not yet say we're not a party to. And we should not be threatening to terminate the states of the United States and their efforts and agreements with foreign states to comply with climate change obligations. That is part of the Compact Clause of the US Constitution. It is legally permitted, at least when Congress permits them, for states to do that. We should not be intruding on those, and it's somewhat ironic for an administration that's supposed to be about states' rights on many other things, say reproductive rights, to say we will trump states' rights when it comes to climate change that definitely affects the wherewithal of their own citizens. We also need, under the international rule of law, to recognize that climate change is now a part of customary international law. If you don't reduce the conditions for advanced climate change, you're just as much engaged in pollution as you were back in the Trail smelter case in the 1920s, when you failed to control sulfur dioxide fumes crossing the US-Canadian border. We see that hint in the Law of the Sea Tribunal's advisory opinion that said that just because you're not a party to UNCLOS doesn't mean you can do this, or even if you're a party to UNCLOS, what you do and fail to do on climate change constitutes marine pollution. I suspect you'll see something similar from the ICJ. That is, what we're talking about is legitimate expectations encouraged by decades of practice of states on the issue of what transboundary pollution is, whether it's on climate change or other things. It's also needlessly confrontational to say we will just not do any of these things. You could reduce your NDCs. You could address the problems that you may have with the current regime on climate change. But it reflects this zero-sum approach to international organizations, that you're either with us or against us, and therefore we will just walk out.
And of course, a lot of businesses want to comply.
Of course, this is consistent with what I've said about anti-corruption. But let me just take very quickly, I know I'm running out of time, two things that are not part of the media scrutiny. For example, the announcement by the administration that will authorize deep seabed mining, that sent a shock through the international community, and not just law of the sea lawyers, but environmental lawyers. The US is not a party to the Convention on Law of the Sea, but it has accepted the provisional application of Agreement on Part 11, the deep seabed regime, which was concluded to satisfy the Reagan administration on the deep seabed. Under that regime, which we have participated in and acquiesced in for many years, the US and all the parties to UNCLOS have long understood that the deep seabed is not some terra nullius for the first pirate to show up and dig. That is, that it is subject to multilateral rules, including on environmental damage that may come from it. Neither the US nor anyone else has a pre-existing legal right to unilaterally mine the deep seabed and ignore those rules. And I would think that it is up to other states, we'll see, but some may be inclined to legally treat any such product produced by illegal US licenses as the functional equivalent of illegal traffic in, say, blood diamonds. So I'm not sure how far that should be treated as a good gain for US businesses. And let me just say one word on something that is inexplicably, to my mind, ignored. We have a lot of attention paid to the numerous retreats from advancing civil rights for racial equality by the administration. rightly so. It is shocking that we are now announcing a pause on the federal pursuit of racial discrimination based on disparate treatment. But keep in mind that that's required under the 1994 convention we ratified on the Convention to Eliminate All Forms of Racial Discrimination. For a long time, the US has suggested that there's a connection between progress on racial equality and adherence to international law, and that we were very proud of Brown v. Board in Education and our Civil Rights Act to give us credibility on the fact that we're making progress on this. And yet, that progress is now stymied. We're likely to see very harsh criticisms, as we've seen in the past, but much more so under the third committee. The U.S. is due for its next report soon. We will see if it even files a report to the Convention on Racial Equality. And let me just say one other thing on this racial disparate treatment point. This is a familiar theme, but consistency is not part of this administration when it comes to this. It is a little odd to see the administration accusing Harvard or law firms of violating the law because they are overly sensitive to the merits of diversity, and that the measure of that is precisely the disparate treatment evidence that they are now saying our federal justice system cannot endorse. So I have a lot more to say on CERD, but I'll just stop there.
Footnote, South Africa, President Ramaphosa.
Yes.
So I appreciate, Jose, the way that you have taken something that was a very conceptual question and brought it down to very concrete examples. Also thinking about the rule of law as preventing, in some ways, being a buffer against obvious disregard for the intention that is behind international law. Now, sometimes in trying to measure the gulf of just how far America First goes in rejecting some of our most deeply and widely shared values, it might be interesting to see how America First creates friction with use cogence norms, some of our most deeply and widely held values. So, Jose, Lucy first, and then Jose, where do you see friction between America First and use cogence norms? Is it in law governing the use of force, human rights? Is it the application of humanitarian law, respect for territorial integrity? Where do you see it?
Well, all of the above, all of the above, I
Go to it.
I would say. But I will, I'll go first, but I'll focus, because of my personal experience right now, on Ukraine. As Chip said, I'm a board member of the Register of Damages Caused by the Aggression of the Russian Federation against the Ukraine. This, for those who don't know, this is a Council of Europe initiative. Can't be the UN because of the Russian veto, obviously. And by the way, so far the United States has continued to support the register, although it's obviously not a formal member of the Council of Europe. When thinking about Ukraine right now, the first thing that comes to mind is that the Trump administration, well, the president and the vice president, have both stated publicly that Ukraine started this war. It is, sometimes you just have to go black and white. It is indisputable that Russia invaded Ukraine on the 24th of February, 2022, in violation of the UN Charter. The International Court of Justice found this in March, right away, in 2022, and ordered Russia to suspend the military operations in Ukraine. The UN General Assembly, in resolution ES 11/5 in November 2023, demanded that Russia cease the use of force against Ukraine and withdraw unconditionally. Obviously, this hasn't happened. So we look beyond the UN Charter to international humanitarian law, basic principles of international law. And the best way to illustrate this, I think, is to run down some of the categories of claims that we are registering in the register. And I should say it's a register of claims because there's no claims commission, because there's no source of funds yet. The war is ongoing. Some of the categories include involuntary displacement, death or disappearance of family members, serious personal injury, sexual violence, torture, including sexual violence against male POWs, by the way, quite systematically, forced labor, forced deportation of children by the thousands from Ukraine into Russia, damage and destruction of hundreds of thousands of residential properties, damage and destruction of critical infrastructure and public facilities. Couple examples. Russia launched massive missile attacks on the Mariupol maternity hospital in 2022, and then the main children's hospital in Kyiv in July of 2024. There's just nothing to discuss about whether these are violations of international humanitarian law. Now there are nightly drone attacks targeting civilians and civilians only in multiple cities. This past weekend saw 250 drone strikes in Kyiv and other cities overnight, with I think 19 deaths and many injuries. I've been in Kyiv recently, and it's quite terrifying. So this is bad. We all say this is bad, but for purposes of this webinar, for our leaders to say that this is Ukraine's fault and not speak out in favor, in support of Ukraine, or to condemn Russia, other than a few tweets that aren't very wholehearted. As an international lawyer and a humanitarian lawyer, I find upsetting. Now, of course, it's true that the U.S. continues to provide some military support under Trump as well as under Biden, but now we're seeing more conditions. Now we've got this great negotiation, which is President Trump's comfort zone of bargaining for future U.S. economic rights to Ukrainian mineral resources. And by the way, I think it's fair enough if the U.S. taxpayers are going to support a hot war, one side of a hot war, that there's be some source of compensation, but it has to be fair and not coercion. I won't say anything on Gaza except to recount my reaction, and no doubt others as well, when I was watching live as Trump had that press conference where he sort of thought out loud, it seemed, about the idea of moving all Palestinians out of Gaza in order to create a luxury seaside resort. And I don't know if you were watching, but I turned to my husband, who's not a lawyer, and I said, at best, he's talking about a crime against humanity here. So this is where I can get quite excited about the glee with which the Trump administration seems to ignore international law, because human beings are dying and are suffering. So, Jose, maybe you'll bring us back down to some law on use Gogans.
So everything that Lucy just listed on categories of claims are serious breaches of the Geneva Conventions, which are also war crimes. They are war crimes under the Rome Statute of the International Criminal Court, and I see no evidence that the U.S. is likely to support the actions of the International Criminal Court on that question, or whether or not it actually will convict, say, an Israeli official on the charge of using starvation as a weapon of war. And if the court finds that convincing, I see no evidence that the administration will give it credence, given its de facto war against the International Criminal Court. So it's not just breaches of international humanitarian law, it's also the crime against humanity of extermination and persecution of civilians that I think you can credibly say is happening with respect to at least Ukraine. With respect to jus cogens, much of jus cogens on war crimes is embedded, of course, in our own code of military justice, and I see no evidence that our current Secretary of Defense will enforce that, because he seems to think that it's quaint to enforce the Geneva Conventions. This was said by a prior Attorney General under Bush Jr., but that seems to be back in vogue. And that seems to be in total ignorance of the fact that our soldiers are beneficiaries when we prosecute war crimes on others. Of course, the threats to use force with respect to Mexico, Greenland, Panama, and now Iran on the Iran deal, they raise serious questions under both customary international law and the UN Charter's Article 2.4, because it bans not just the use of force, but the threat of force to settle disputes. Now, much of what the administration has done is under the guise of economic coercion of various kinds, including the mineral agreement with Ukraine, or perhaps a peace deal that is imposed against the will of Ukraine. And let me say international law has something to say about that. The rule of law and international law says that states shouldn't be trying to extort their ways into agreement. We should not be emulating the tactics of the mafia. And so this is affirmed in the Friendly Relations Declaration that is widely cited as indicative of customary international law that defines the principle of non-intervention in domestic jurisdiction as banning the use of or encouraging others to use economic or political measures to, quote, coerce another state in order to obtain from it the subordination of the exercise of its sovereign rights and to secure from it advantages of any kind. So there are doubts about the enforcement of something like a mineral lands agreement or a peace deal that is in fact coerced, even though coercion, at least under the Vienna Convention, is defined as use of force or threat of force. But keep in mind that the Vienna Convention had a declaration attached saying that it discourages the use of economic coercion. And of course, with respect to human rights, a lot of the human rights that the administration can be fairly accused of violating are, in fact, jus cogens, especially when it comes to the treatment of immigrants. Back in 1986, the U.S. Restatement of Foreign Relations had a very conservative list of jus cogens. Here's the list. You don't commit genocide, you don't murder or cause the disappearances of individuals, you shouldn't be torturing or committing cruel, inhuman, or degrading treatment, you shouldn't have prolonged arbitrary detention or systematic racial discrimination or consistent pattern of gross violations of international recognized human rights. Incidentally, that is a list of pretty much the rights that the State Department's country reports on human rights will no longer be reporting on. Is it just a coincidence, or is it the fact that we're coming close to the line on violating most of those? That is, when you forego trials to deport immigrants to notorious prisons abroad, we are inflicting punishment without trial. We are treating non-US nationals, whether they're here legally or not, whether they're on protected status, whether they're here because they're trying to claim asylum. We're treating them as less than human beings owed due process, and that is something that they have under both the US Constitution and international law. We are at the very least aiding and abetting prolonged arbitrary detention by the likes of people of states like El Salvador. And we're doing that in those countries, make no mistake, to try to evade continued supervision by US courts. We tried that with only limited success with Guantanamo. The Supreme Court put a bit of a stop to that, but we'll see whether they do that. We are approaching clandestine tactics in some cases of disappearances of immigrants that do possibly look like those that we saw in military rule in places like Argentina or Pinochet's Chile. That is the picture of President Trump embracing Saudi Arabia's MBS speaks volumes. When he said in his speech in Saudi Arabia that he had no idea how the crown prince was able to sleep at night because he was so interested and embedded in making Saudi Arabia great. Let's just say lawyers around the world may have a different view about why MBS has trouble sleeping at night. That is, the group hug between MBS, Trump, and an army of business leaders who went on that trip tells us a great deal about the priorities of America First, that it valorizes, and about the American values it seems to ignore.
Thank you, Jose. You began talking a little bit about the interface between what is going on domestically and what is going on internationally, or how they seem to be interpenetrated with one another. So, domestically, we are focused on threats to the independence of judges, threats to the independence of lawyers, threats to freedom of expression and freedom of thought, and also threats to the right to fair trial. That's what we're focused on domestically. Do you see a direct line between that and what's going on with America First internationally?
Turn this over to you, Jose,
Okay.
as professor.
Okay, so yes, it's almost seamless. So as an example, just take a letter sent by the current UN Special Rapporteur on the independence of judges and lawyers by Meg Satterthwaite, who happens to be my NYU colleague. She sent this to the administration on February 20th, given all the threats that we have seen with respect to lawyers, prosecutors, law firms, and law schools. And she was asking how the administration says those threats are consistent with Article 14 of the International Covenant on Civil and Political Rights that the U.S. is a party to, which says you should have access to independent courts, both as in a criminal proceeding as well as in civil proceedings. She pointed out that it's not just Article 14, it's lots of other stuff, as I say, in terms of the interpretation of these treaties over time that is consistent, and in this case, inconsistent with the international rule of law. Basic principles on the independence of the judiciary say that the government has to guarantee an independent judiciary, no restrictions, improper influences, pressure, threats, direct or indirect, against impartial judging, no non-judicial interference with judicial proceedings or other government interference with the judicial process. The UN guidelines on the role of prosecutors is similar. Prosecutors are supposed to perform their functions without intimidation, harassment, without exposure to civil, penal, or other liabilities. They have freedom of expression, association, like other citizens, and governments are supposed to ensure that prosecutors can prosecute crimes committed by public officials, including corruption, abuse of power, grave violations of human rights, and other crimes recognized by international law. You should not interfere, in other words, with how a prosecutor prosecutes this by trying to intimidate them. And the UN basic principles on the rule of lawyers are similar. Lawyers are supposed to be able to serve their clients. You shouldn't associate a lawyer with their client's position or what they say in good faith in court. They are entitled, like all citizens, to freedom of expression, belief, association. Threats to all lawyers, merely because they took on causes that displeased the president, may indeed constitute unconstitutional bills of attainder. This was an argument raised by an amicus brief by 27 former U.S. government officials. And those, by the way, were from both parties. But this business of not having bills of attainder, that basically retributive actions, are also in violation of international rule of law. Turning the U.S. Justice Department into an agent of retribution against the president's enemies is not, or should not be, a Democratic or Republican issue. It's a rule of law issue under both national and international law. And I take no pleasure in saying that. I want to make sure people understand that critics of this administration under international law are patriots. We defend this country. We have defended this country. We simply believe it is in America's interest. Make America great through law. And let me say, because I'm in a law school, a bit of a word about the administration's Harvard derangement syndrome. Let's be candid here. There may be serious problems with respect to how Harvard has handled student protests in the past. But as the co-editors-in-chief of the American Journal of International Law have affirmed, free academic inquiry is essential to the teaching, study, and the practice of international law. In the US, academics have a special responsibility to look critically and to protect the international rule of law, because U.S. courts cannot be expected, as I mentioned before, to address it as much as they do violations of U.S. law. Attacks on DEI policies, the entry of foreign students to U.S. law schools, and how much the universities should intrude on their privacy in their social media accounts and so forth. All of that threatens the diverse points of view that is needed to teach law, especially international law. America Firsters should encourage such diversity. If we want, as they say they do, a critical reassessment of prior U.S. interventionist policies that President Trump criticized in his speech in Saudi Arabia, if you really want that, you need the voices, believe it or not, of critical race and third world approaches to international law scholars who stress that. You need them just as much as law and economics scholars. We need the input of foreign law students, foreign academics, that are now being threatened from entry into the United States. We need them precisely to engage in the critical reassessment of the old rules of the game that America First want to change. And they want to change in those rules. Well, we need to engage those scholars in those rules. Those students, just like all other immigrants, come to the US lured by many things. But one of those things that lures those students is one of the things that made America great. It's renowned and independent universities. We have no business undermining that.
Thank you, Jose. Lucy, Jose has given us from an incredibly patriotic perspective, a description of the ways that America First violates international law, not just out there abroad, but even in relations to things that happen within the United States. Lucy, in your experience, why should U.S. violations of international law in particular, why should U.S. violations of international law matter so much?
Well, first I'll emphasize what Jose said. I consider it patriotic to speak out against what's happening. We were served in the State Department together. I'm proudest of my public service. I'll give you a short answer, Chip. There are two reasons. First, the United States was the primary architect of the post-World War II international rules-based order, and so it follows naturally that we should be proud of it and continue to protect it, or at least its foundations. In my household, every child always got to answer one question per day with just because. And I say just because. The second is that, as Jose has emphasized, even though this post-World War II order is not without flaws, it protects the United States. It protects our interests, which is what foreign policy is all about. And if we don't do it, it's going to be, well, as we don't do it, it's going to be very interesting to watch how the European Union and other organizations step in to take over that role from the United States. So I can recommend two good articles in Foreign Affairs, May, June. Nigar Woods of Oxford wrote, Order Without America, How the International System Can Survive a Hostile Washington. And already mentioned by Jose in the American Journal of International Law in April, Monica Hakimi and Jacob Katz-Kogan wrote an article called The End of the US-Backed International Order and the Future of International Law. It's superb. It covers all the things we don't have time in 75 minutes to cover. The thesis is that post-World War II, international law was constituted with and dependent on power, on US power, intertwined as sort of an odd couple, they call it. And as this order changes with the Trump administration, the international law system will change in content and architecture. So our question, going beyond today, is how will we manage our role as international lawyers as we struggle to protect what international law protects?
As we are rounding into the last few minutes of our time together today, I want to pose the most fundamental question, the one that should interest everybody. Is America First making America safer? Is America First making America stronger? Lucy, what do you think?
Well, I'm going to take the opportunity to pose a question to Jose. When we did the Hudson Medal interview, Jose said that he saw three existential threats warranting concern about the effectiveness of international law: nuclear war, climate change, and future pandemics. And Jose, you noted that the golden age wasn't so golden post-Cold War. And you said, and I quote, "I don't think international law is in more trouble than in the past," end quote. What do you think now?
Well, she's trying to get me all riled up. I do agree that with respect to climate change, pandemics, and nuclear war, we are closer to the doomsday clock than when we spoke even at the Hudson Medal back in April of 2024. Those three threats now loom larger. America First threats to climate change and global health is, I think, been widely recognized. When you are hostile to vaccines domestically, you're obviously hostile to the organization that helps you on vaccines. And yet we seem to have lost track of the fact that the health of other nations, including with respect to vaccines, invariably comes back to affect ours in a global interdependent world. And we're ceding leadership, as I've indicated, on climate change to others. But less attention has been paid to the growing threat of nuclear war in the age of Trump. According to the best expert information we have, and it's limited and flawed, China's nuclear arsenal has accelerated and expanded greatly over recent years. We're told that China now has roughly 500 nuclear warheads, much more in production. It now has the fastest growing nuclear arsenal of the 9 nuclear-armed states. And while the Trump administration has focused commendably on Iran's nuclear capabilities, it has obviously undermined the Iran deal, but better late than never. And so that's great. But the tariff war and the threats of decoupling with China doesn't seem to have raised questions for the administration on whether cooperation with China or with Russia with respect to controlling nuclear armaments is on the agenda. So with respect to those as essential threat, I'm not sure that we're better off. But the overall thing that I said back in ASIL was that 80 years is an awfully short time for international law. So even if you think that 1648's Treaty of Westphalia defined the beginning of it, it's only been a few decades since Nuremberg ushered selective international criminal accountability, only a few decades of extensive treaties on a variety of issues, only a few decades of turning to international adjudication of various kinds. And therefore, if you take a look at the spectrum of international law, it wasn't that long ago when there were no restrictions on use of force, and it was all about just war. It wasn't that long ago that we had no restrictions on what states could do, for the most part, when they resorted to war. And so the key question, I think, that Lucy raised at the beginning of our talk is, how will the rest of the planet respond? Will they seek to defend aspects of the current international order that the U.S. has been the principal aider and abetter? Will it step in to actually correct its flaws, reform it? And as lawyers, we need to help them do that. And that includes listening to reforms that they may have in mind, so that the international law of the future is a bit fairer with respect to North and South, for example. And I'll stop there.
Thank you, Jose, and thank you, Lucy. Thank you to our audience members. I know that time is the most valuable currency that we have. We can't make any more of it. I want to thank everybody for being so generous with it today. I'm going to close with a quote, first from Dante and then from Jose. In the middle of the road,
Dante and Jose.
the middle of the road of my life, I awoke in the dark wood, where the true way was wholly lost. The Divine Comedy begins with a sense of disorientation, foreboding, and potential malice that many of us feel today. But on the occasion of receiving the Hudson Medal, Jose said, even if you think international law is in crisis, we should not let a crisis go to waste. likewise, Dante was also talking about opportunity. How do you know that you are being handed an opportunity for profound change? How do you know that you have the opportunity to do something really radical, not in the political sense, but fundamental? This is how. But Dante was also saying, pay attention. You can't sleepwalk into your own destiny. You can also feel the quiet of the moment at the beginning of the Divine Comedy. We need to have that profound inner silence to silence the voices that got us here and are giving us a million reasons not to change anything we do. And finally, the last thing that Dante says is, there is no clear way forward. There is no GPS. There is no map. There is no set of directions. The only path is the one you make. Thank you. And on June 5th, we will have the next iteration in the series on promoting promoting rule of law. It will be June 5, 10 a.m. to 11:30 a.m. Eastern, hosted by Allison Fitzgerald, and it will address economic coercion and sovereign decision-making. In the meantime, thank you and goodbye.